Counter affidavit we filed within 4 weeks. First, we joined the refining within 4 weeks. Just after 8 weeks. Next.
It seems to have become infructuous notes.
Yeah.
The counter affidavit, the state has issued a policy notes. The policy is not the subject matter of the writ petition. I was the petitioner before the High Court notes. And similar matters where state took a view that is being passed by different state fellows, this Honorable Court has dismissed such matters.
So the judgment may be set aside. If it's infructuous, then there's no problem. The impugned judgment may be set aside.
Sorry, because the policy and the judgment are in line with each other.
Right?
No, according to him, straight.
Mr. Shankar Narayan, please.
In fact, this view that is being taken by the state government, a notification is annexed in the counter affidavit dated 29 January. And that is a consistent view taken by all states as well as all the Honorable High Court. One of the orders I have of this Honorable Court, where a policy was passed by the state, it is only an inclusion of their adding.
In this case, it's subject matter. In this subject matter.
Not in this subject, but the issue is same. It is for different state.
Leave aside of that.
The issue.
Leave aside of that, please.
The simple question is, can the High Court dilute the standards which are statutorily required to be prescribed by the NCT, which has been done? On a concession made by the state government, we are all eligible candidates, 1 lakh of us, we are waiting for them to have the advertisement issued, which has been issued. Now we are the only ones who are eligible.
But Mr. Shankar Narayan,
Yes.
as per the policy, some clause was there.
Yes.
That clause has been referred in the order issued by the High Court. If I am not
correct. Your Lordships are right. Recollecting absolutely right.
On the basis of the same,
yes.
The High Court said yes, the government can do in terms of this policy.
Correct. Yes.
So that was given to them. Now, what is the statutory rule?
So I'll just explain. So the concession that is made by the government is that, look, the petitioners, my friends' clients, have come to the court saying, state has not conducted the state Ctet for a long time, since 2016.
That is right.
Therefore, we have no avenue. We are qualified with the Ctet, which is of the center. Allow that to be used for the advertisement you have already issued. The Advocate General says, I concede that may be used. Our stand is, we took part in 2016 in the Ctet. We are fully qualified under the Ctet. The statutory scheme is as follows. Section 23 of the RTE says, 23(1), that the academic authority who will lay down the minimum eligible requirements will be the one notified by the central government. 23(2) says, in a situation where a state has certain lack of institutions or a lack of candidates, the central government will relax the minimum eligibility criteria. So the state has nothing in its hands. Only central government can relax. The under 23(1) in 2011 itself, NCT is nominated as that academic authority. NCT issues its notification of minimum eligibility criteria and says very clearly that the only minimum eligibility criteria is the TET to be conducted by the appropriate government. Section 2A of the RTE Act says appropriate government is the government of the state, which in this case is Jharkhand. So Jharkhand has conducted that TET. 1 lakh candidates are available. So even 23(2), if it were to apply, will not kick in because A, central government has not relaxed it. It's not for states to come and relax. Central government has not relaxed anything. And B, there is no lack of candidates. 1 lakh of us are here. 13,000 posts are advertised. We are the only ones who are eligible to proceed on. Because of the state's concession, the state, despite having issued the advertisement, has taken no further steps to fill up those posts. And the High Court's judgment now says, based on this concession, you can, for a period of time, have people from there. Which is what we are objecting to. We are the only ones who are eligible, legally eligible. This is the entire clear.
First week of May.
Some date may be given.
It is very simple.
Inconnected matter, spare copy not filed.
In some connected matters, some issues are there.
Yes, I will file it today. The spare copy.
You see now, the problem
on the last day.
we want to hear that it's a problem.
I apologize.
One tag matters.
Point 2 is not for the same impugned order, that is of Bihar.
The point is the same, na?
Point is similar.
Point is the same. Point is the same. It is of Jharkhand. Yes. It is of Bihar.
Indeed.
But point is the same.
Point exactly. No doubt.
Launching in the lead matter, the state has already filed counter affidavit, where 60.1 state may be permitted to file counter affidavit.
You also consider saying that all
service nahi hai na, service you made effective on filing the fresh copies. Full stop. Counter, in some of the cases, counter has not been filed. It will be now filed within 6 weeks. Rejoinder within 2 weeks. 8 weeks, July mein lagao. Pura.
Grateful.
Very well. I'm grateful.
Thank you. Yesterday's matter?
Yes.
Day before?
64, your lordships. They had agreed for a settlement, and regarding possession, can we just point out the Google map? Because there is a
My lords.
coming to an agreement if your lordships may interfere.